Okay, good afternoon, ladies and gentlemen. It's September the 13th. It's 1 o'clock, and I'm going to call this meeting to order at, I believe it is 1 o'clock, right on. I can confirm that all members are present for today's meeting, either in person here in the room or via Zoom. I can also confirm that the CAO, the clerk, and other members of our senior management team are present here with us, either in person or on Zoom as well. And I'm going to ask you to join me in acknowledging that we are on lands traditionally occupied by Indigenous peoples. Indigenous peoples have cared for this territory for the benefit of future generations, and their stewardship throughout the ages is recognized. I would also draw your attention to the fact that today's meeting is being live streamed and recorded on the Township of Muskoka Lakes website and YouTube channel. And by participating in this open public meeting today, you are consenting to your image, your voice, and your comments being recorded and posted online. As we usually do, or always do, we did invite public input at TML public comment at muskokalakes.ca. However, none was received for this meeting. I would also notice, give you notice that tomorrow or later on today, we will be dealing with a supplementary agenda. The supplementary agenda was issued to add the following matters. Pursuant to section 7.2.1 of Council Procedure Bylaw 2019-079, a supplementary agenda was issued to add the following. 10.A.I, evidence from the appellant, re OTR 2023-13, appeal to order to remedy tree conservation and site alteration at 14 Armstrong Point Road. Director of Finance, re 2023-2024, insurance renewal, and finally 10 sub F, report from the Director of Legislative Services or clerk, re community fundraising request, Candlelighter Simcoe Childhood Cancer Awareness Month. At this time, I want to ask if any member of council has a pecuniary interest in any of the matters that are disclosed on the agenda. I'm not seeing any. I'm actually going to confirm that I don't. Nope. I'm not seeing any, so we'll note that as a no. I would also remind everybody of just a simple matter to expedite this matter. And I would remind all participants that members shall physically raise their hand until the mayor, that's me, has confirmed the vote. If the vote is unclear, a verbal vote shall be recorded by the clerk, and that will not be considered a recorded vote. So we are open. Welcome to everybody. I've got a couple of requests to deal with the agenda matters. I'm going to do one first, and that was Councillor Edwards asked me to give him an opportunity to correct something that I think you said earlier today. Councillor Edwards?
Yes, thank you very much. When I was talking about the Windermere Cherry Fox Run silent auction, which is on their website, I neglected to say it was a Samsung S23 Plus phone that was auctioned off, and that will be approximately $1,700. So if anybody is interested, they're welcome to bid on that and any other items. Thank you very much. I'm sorry for the mistake.
Thank you, Councillor Edwards. Okay, we're going to start with the consent agenda. Is that where we are? Yeah. Consent agenda. And I will just start with what was circulated earlier. First one is this is the document. Yeah. Approval, consideration of a resolution to approve the following minutes and action items. Number one, August the 16th, 2023, General and Finance Committee minutes and action items 1 through 7. Number two is August 16, 2023, Council minutes. And number three is August the 17th, 2023, Planning Committee minutes and action items 1 through 8. Does anybody have anything to say about any of those or need anything set aside? All right, then all in favor of that? Did I read the resolution? I sort of read it. So I'm going to read it just for clarity. Be it resolved that the mayor and council adopt and enact the following minutes and recommendations contained in September 13, 2023 consent agenda and direct staff to proceed with all necessary administrative actions. Number one, August 16, 2023 General and Finance Committee minutes and action items 1 through 7. Number two, August 16, 2023 council minutes. And number 3, August 17, 2023 Planning Committee minutes and action items 1 through 8. All in favor? That carries. Thank you very much. All right, got a couple of things before we move on to the senior management team reports. New business. There's nothing noted. Does anyone have anything to add to the hopper right now? Seeing none, I'm going to deal with the minutes from the June 13, 2023 meeting of the public library. We don't approve that. Anybody with any comments on that? That was just for information, so we'll move on. We're going to move to the next item of business, which is the senior management team reports. And I am going to adjust the order of things. And the first one that I'm going to call upon is Director Becking to, I think the first one is the award of contract for the wall, the Highway 118 wall. Director Becking.
Thank you, Your Worship. In accordance with township policy, the work was tendered and we received a bid in the amount of $1,767,785 from Bronte Construction. The bid was in excess of the budget that had been established by council. And we spent the last month going back forth with the contractor to negotiate some amendments to the contract. The contractor has agreed to some reductions totaling approximately $170,000 in the form of amendments to the traffic management provisions within the contract, as well as an adjustment in a supplier for the stone facing of the proposed wall. This will bring the contract down by the amount I've indicated. We've also negotiated with the consulting engineers to carry on with the contract administration and inspection of the works. One of the implications of the contractor's proposal was to move the work to March of next year. That will have some substantial benefits, not only financially, but also in terms of the practicality of the proposed work. It will reduce the influence or the impact of the proposed works on the main street in Port Carling, and will get us through the lion's share of the winter without any disruptions. So that was seen as a positive benefit, as well as reducing the cost of the project by something in the order of $100,000. So that's the plus side. On the negative side, we are not moving forward with the work as we had anticipated. We've indicated to you that the work has some urgency, and I won't mislead you in thinking that there are no risks associated with the proposal. I can say that we've experienced the initial movement and the failures in the wall. Since that time, there have been no movements that we've detected, and the situation appears to be stable. That, however, can change, and it can change quite rapidly. So we are putting in place a monitoring system. We will monitor the conditions weekly or as necessary. If conditions change, we may have to accelerate the scheduling of the project, assuming that you proceed or authorize us to proceed with executing an agreement with the contractor. I think on another positive benefit is if we do experience problems, we will have a contractor contractually bound to us, and he will be able to respond far more quickly than if you choose to exercise the alternative, which is to not award the contract. In which case, if something does happen in the intervening period, we will not have somebody who can respond promptly to an altered condition. So those are the benefits and liabilities of the current situation. It is staff's belief that the savings are meaningful and can be realized. We can monitor the situation, and the colder weather will work to our advantage. So I think it is a viable option at this point, but it is not without risks. With that, Your Worship, I'd be happy to answer any questions.
Thank you for that report. Anyone with questions for Director Becky? Councillor Bosenworth.
I'm just curious as to what kind of risks we are exposing ourselves to. Is it things like significant rainfalls or snowfalls that can cause it to crash more? More?
Certainly, the slope can become destabilized, and it could cause further failures of the wall, which in turn could affect the adjoining building.
Councillor Zavitz.
Thank you, and through you to the director. Does the landowner have any responsibility? So I know this is a late question, but does the landowner, the people that own the building way up there, have any responsibility to this, or does, we own to where we own and then their property carries on? Do they have any liability here?
An interesting question, Your Worship, and the short answer to the question is no, at least not in my opinion. The existing condition was created by the municipality, and the existing wall, such as it is founded on the township's, the land that we have access to for the purposes of our sidewalk. So we are the responsible party, in my opinion.
Thank you. Councillor Kent.
I actually have a couple questions. I guess I'm astounded at the cost involved here. This is such a big expense, and I realize it's a big project, but it's a project we don't get a lot of good feelings out of. If you want to put it that way, it's building a wall that's already there in town. It's not fixing the dock at Port Sandfield. It's not doing anything that the community can feel, in my opinion. But it's a lot of money. It's gone up in bid in value twice. It was first like about $1 million, which is a guesstimate. Then it came in at $1.3 million. Now it's $1.7 million. We only had one bid. Is there a reason why we couldn't get more than one bid for this? That was my first question. And then I have a second one after that.
Your Worship, I think it's a relevant question. The contractors, there are not a lot of contractors in the local area who have the capacity to do this kind of work. So for people to come in from outside the area represents a significant logistical issue for them, and that frankly is reflected in the cost. There is no question that tendering later in the year can be more problematic because, of course, contractors organize their business in such a way to plan out their year's work in April, May, sometimes June and July, but seldom, at least in the kind of work that we're talking about. It's unusual to put out this kind of work outside of the larger metropolitan areas at the time of the year that we have. The the contractors are going to be busy, and there's an opportunity cost which is reflected in the price. I think also you're seeing, frankly, the effect of labor shortages and capacity shortages within the economy. Frankly, this is not uncommon for us. To get one bid alone, quite frankly, is a positive.
Can I just, when we looked at the original drawings, and I think it was it was in the fall, I think, or I don't remember what it was. There were two ways of approaching this. I think we chose to go for the cheaper one, didn't we? Of
We
the
did.
two? So this is now it coming in more expensive than the more expensive way?
No,
Okay.
no, Your Worship, I have said to you, I know I have said to you that this is not going to be cheap. If you were to ask me, am I surprised by the number that we're seeing here? No, I'm not. My experience in building miles of retaining walls over the course of my career is that they are very expensive. And this situation is particularly difficult, probably one of the more difficult situations I've dealt with in my career, given the proximity to the utilities and the proximity of the building. I have had a situation in my career where that building ended up being taken out as a result of the failure of a wall. So it can happen. I personally experienced it. I would argue that, or my recommendation to you is that this is not a game to play chicken at. My recommendation is before you. I think we should proceed because that gives us at least some degree of protection. I think here is an example of how not to do something. And here is an example of the benefits of asset management. This should have been known to all of us 5 years ago. And we should have had time to plan for it. We didn't, because to be quite honest with you, until 2 years ago, we didn't even take stock of our retaining walls. They are not typically considered as part of the statutory requirement for an asset management plan for our bridges. It's only as a result of my insistence that this is the reason why. This engineering, I apologize for the moving target in terms of the budget. This is what should have happened was we should have done the engineering first, then come to you and said, okay, it's going to cost X. And then it boils down to a question of the marketplace establishing what X is. But usually any engineer worth his salt should be able to get you within 2 or 3% of where the market should be. We've been playing a rearguard action all the way through this particular process. And I would argue that this is an example of how not to do business.
Can I just have a follow-up? I said I had two.
Go ahead.
Yeah, my second question was really more for our discussion, which is, and I had this discussion already with Councilor Becky, but so we have $1 million in the budget for this year for this project, give or take. I know we're over budget on a whole bunch of other projects, but I sort of feel like if we had that $1 million, we should fund it in the existing budget so that next year when the budget comes forward for the 2024 year, it only has the increment in it in order to not make the 2024 year worse and the 2023 year better, because we've already got the tax increase and the things have already gone through for the existing year. I would just, and I realize Director Donaldson's going to tell me it's just in one out and out the other, but it's a way it looks in our 2024 budget. And we're gonna have another $1 million in there, which we've already had in this year's budget. So I want to pre-fund it, get it behind us. I don't really care if we're $750 over. That's his gravy.
Thank you. I'm going to call on Director Donaldson since he has joined us.
Yeah.
You respond if you would,
Yes.
please. Bet you wish you stayed back.
Thank you, Your Worship. So I guess what I'll do is I'll explain to you how we'll do it, how we would normally account for it, and then I'll give you the opportunity to respond and tell me where we would vary. But so the exact reason why we have reserves are for these types of things that, you know, some are planned in our 10-year plan and some pop up unexpectedly like this one. The contributions to reserves, we try to keep fairly consistent and smooth, so we don't have a lot of volatility in the tax rate on an annual basis. We only get one kick at the can to set our tax rate every year, and that's when we do our budget, and then we're kind of set. So when we have situations like this, we will draw into reserves more than what we had actually forecasted in our budget, which will just lower our balances as we go into the next year than what we would have forecasted. And then
Can you say that one more time?
so we'll forecast based on our capital budget. We will forecast what our closing balance will be for our reserves. When we have unexpected things like this, our actual balance will be lower than what our forecast, because we had to draw more out than what we thought we were going to. Because when we start the year, we think we're only going to draw out what we planned for capital expenditure. If we have these types of events and other in-year approvals, we did some bike lanes earlier in this year that were not in the plan. So that just lowers our year-end forecast, or sorry, our year-end reserve balance than what we thought it was going to be at. And then what we'll do is use the contributions to reserves to replenish that over time. So it's not like a immediate one-to-one hit every year, because if we do that, we create immense volatility in the tax rate. One year it'll be 15%, the next year it's 5%. And what we try to do is keep it fairly steady for ratepayers.
You've put the forecast and the tax levy this year reflected $1 million for this project. If we don't spend it, so then you're going to say, well, I'm going to use that $1 million with all the other increases we've had and projects that are over budget, 750 that we know is sitting out there. So I'm just saying, I'd rather have the 750 go through as we had over budget projects. The $1 million is paid for next year. We had that in our tax levy. Next year, instead of 12.8, we won't have an extra $1.7 million in there that, you know, was already in this year's levy. So I know it's really just in one, it's all timing, but it's a presentation of how it looks. And I would rather not have to go at it twice. We've already gone at it once. Now we're going to go back at it again for discussion.
Can I just cut this off? Is the decision or the answer to that going to change your opinion? Is it material to the question at hand? Do we need to do the
but I
work or
think
make
it's
the
an important
contract?
issue as it relates to our budget for next year.
Well,
$1.7 million of a problem.
That's fair. I'm going to suggest we focus on what we're being asked to. Thank you, Director Donaldson, and move this forward or not. And then we can take that up, that issue up either offline or in a budget discussion. Anyone with another question for Director Becking? Any other questions? Oh, sorry, up in the sorry, Councillor Roberts, go ahead.
Thank you very much, Chair. To Director Becking, March would be the start date of this, and you say it's not without risk. Should we spend them? Should we just bite the bullet right now and get it done to mitigate, to stop the risk? Or do you think the risk is manageable and likely or highly unlikely to happen?
Your worship, I cannot stand before you and tell you it will or will not happen. I can tell you that we've managed to come up with about a 10% saving in the cost of the project. I think we can manage. We can't manage the risk. Mother Nature will have the final say on that. What we can do, however, is we can monitor the situation. If there is no destabilization of the slope, then we can wait until the time and do the work. By awarding this contract today, at least you have a contractor contractually bound to you, and he can respond if the situation changes. And I'm afraid that's the best answer I can give you.
Thank you. Any other questions? I actually have one, and it's a quick one. Does this impact how or when or where we clear snow in front of that failing wall?
No, it does not. Winter operations will be normal from beginning of winter until March, the contractor, as part of his revised bid, is responsible for any winter operations once construction starts. So that has been covered off.
Councillor Zavitz.
Thank you, and through you, just anyway, a couple of properties down, we witnessed a real estate company completely level that rock we're discussing 2 houses down, which is the subject of our $2 million with tax in. It's a couple of $1 million. This is going to sound bizarre, but I mean, have we considered legally, does the township ever appropriate any, I mean, do we ever, I mean, if you think about it, we were looking for parking in downtown Port Carling. If we were to somehow be able to purchase this property, level it and make it a parking lot, I mean, that's a whole different way of looking at it. But like I say, the real estate company completely, we watched them tear the rock out and get it to ground level. And now it's parking and a building. Have we thought about that at all in terms of, I know it's completely obtuse sort of perspective, but the guy would want $6 million for his property probably, but.
My suggestion would be that had we thought about that, we would have done so in closed session.
That is true, Your Worship. I think I can safely say, however, that possibility was examined and rejected very early on.
Okay, I'm not seeing any more questions. I'm going to read a resolution. Moved by Councillor Roberts, seconded by Councillor McIntyre. Be it resolved that council award contract T-2023-51 to 2220742 Ontario Ltd, operating as Bronte Construction, for the revised bid price of $1,659,965 plus HST. And that the existing design contract for T-2023-51 with Tatum Engineering Ltd be extended to provide contract administration and construction inspection services at the estimated price of $111,125 plus HST, and that the approved capital budget for the Medora Street sidewalk wall be increased to $1,771,090 from the current approved budget of $1,360,000. And that the Director of Public Works be authorized to execute the necessary documents to proceed with this contract. Anybody have comment on that before I call? Seeing none, I'll call the vote. All in favor? Anyone opposed? That carries. Thank you. Thank you, sir. We're going to move you back up one notch, if you would please, to the Ranwood Yard issue.
Thank you, Your Worship. In accordance with township policy, bids were called for the replacement of the Ranwood fuel system. One bid was received from Comco Canada Inc. in the amount of $205,093. Staff recommend that the contract be awarded to Comco in that amount, and that I be authorized to execute any documents necessary to proceed with the work.
Thank you for that. Anyone with questions? No, I'm going to read a resolution. Moved by Councillor Bosenworth, seconded by Councillor Kent. Be it resolved that council award contract T-2023-18 to Comco Canada Inc. for the bid price of $205,093 plus HST for the removal and replacement of the fuel system at Ranwood Yard, and that the Director of Public Works be authorized to execute the necessary documents to proceed with the purchase. Any comment? All in favor? That carries. Thank you very much. Thank you. All right. I'm going to go back up to what was originally not the first issue on this list, and it's a report from the Chief Municipal Law Enforcement Officer regarding 14 Armstrong Point Road. You see, oh, there he is online. Welcome. Mr. Kennedy, how are you?
Good afternoon, Your Worship.
The floor is yours if you want to talk to this report, please.
Okay, Good afternoon, Your Worship and members of council. This was first scheduled for last month's council meeting in August and was ultimately deferred due to a late submission that was received by the appellants with some claims that had yet to be known by staff. So we asked for a little bit of time in regards to trying to determine, the truthfulness of the claims or what they, if they were relevant at all. So after that deferral, I had a conversation with the appellants just downstairs at our table. And I requested, there was one claim in regards to hydro, cutting a bunch of the trees that were on the property down. And I asked for some proof in regards to that, as it was indicated that they had already spoken to hydro and they were going to get it. Unfortunately, I still have not received that today. But I think what I'll do today is I'll give an introductory kind of rundown on the investigation so far, and then I will turn it over to, I guess, the appellant in regards to their claims, and we could go from there if that pleases Your Worship.
That's terrific. Thank you. You go ahead.
So on June 16th, 2023, bylaw staff received a complaint for the property known as 14 Armstrong Point Road. And it was in regards to more or less a property standards issue. It was with garbage scattered around the yards, the yard just looking unkept, some dilapidated buildings on site. And therefore, that same day, we completed a site visit investigation on the property. While we were there and noted numerous amounts of property standards issues that were dealt with through another order under property standards, we also noticed that there were multiple trees cut down on the property in various areas of the property. All of which were within 200 feet of shore, which would be the Indian River in this location. It was determined that around 20 to 25 trees had been destroyed, and the trunks of the destroyed trees were still present on the property. And there were multiple piles of wood that would indicate to myself that they were about to be used for fuel for campfires down closer to the shoreline. While investigating closer to the shore, we also found that there was a pathway that had been constructed virtually right next to the Indian River. And this was seen by way of, it appeared that fresh crushed gravel had been deposited right at the shoreline. And it also appeared, based on fresh tracks from heavy machinery, that this site had been cleared very recently with the evidence of the fresh tracks, along with fresh dirt or earth that was on either side of where I would assume it would have been a bobcat or some smaller heavy machinery that had done this. But on either side, it appeared that there was fresh dirt or earth that had been moved around. And just based on our determination, it also appeared that a bunch of branches on some trees in that general area where the pathway had been constructed had been recently limbed. Additionally to this, on the right side, if you're walking on the shore, going backwards towards the property of number 10 Armstrong Point Road, it appeared that there was a significant amount of undermining of tree root systems on the right side based on the slope of the property, as it is a little bit of a steep slope that's closer to the shoreline. And therefore, based on those findings, an order to remedy was issued, which is up for appeal today. In Appendix 2 of this report, it describes the order to remedy and what we are asking for, what we are ordering with the sedimentation control measures along the shoreline, which is a common thing that we order when there are tree conservation or site alteration contraventions found. We always ask that before a revegetation plan is started and implemented, that a sedimentation fence is installed across the shoreline so that it mitigates any erosion that may happen while there's remediation of the property. Along with this, we ordered that a renaturalization plan was to be submitted to the township no later than August 15th, 2023. Of course, being September 13th, we are past that. To date, we still do not have any renaturalization plan from the owners at this time. And through that, there were multiple items that we asked for within this renaturalization plan from A to H. And then the third issue to be ordered was the owner shall complete the revegetation plantings in accordance with the township approved plans no later than October 31st of 2023. I would assume that council has seen the photos in Appendix 1 to give you a better idea of what damage was done to the property and what we found on our inspection. And from there, I don't have any further evidence to provide to council at this time, and I will leave it to the appellant. Thank you.
Thank you. I'm going to ask everybody to pay attention to this for one quick second. We're in a quasi judicial sort of setting here right now. So we need to be really scrupulous about how we answer and ask. And what I'm going to ask everybody to do at this point in time is if you have any questions that need to be clarified by Mr. Kennedy, I'd ask that you raise them at the present time. And I know we give lots of latitude. Sometimes questions are really comments. You can't take comments until we've heard from the other side. So if anybody's unclear, I think, you know, if the report was unclear, the photographs are unclear, the report today was unclear, I'd like to get that cleared up so that Mr. Kennedy's statement and report are complete and the record is complete from one side. Then we're going to call upon the appellant to give their discussion as well. We can have our debate afterwards if we need to have a debate, but right now questions are what I'm looking for. Nobody, Councilor Nishikawa.
Thank you. I just want to request that I can reserve my questions till after I hear from the appellant as well. Thank you.
Certainly can ask questions after the appellant as well. Okay, I'm seeing nothing else. Then I'm going to call upon, we did have a delegate registered and it is Sandra Fawcett. Is that, Sandra, you're in the room. If you wanted to come forward and speak to this issue, I'm going to, I don't know if remind you is the right word, but I'm going to make a comment, and that is that we really are only here to discuss the contents of the order. And I'm going to ask you to stick only to those points in your speaking notes. And I'm going to rein you in if we talk about other things. The only things that matter are documented in the order. And the question is, do you have any response you think we need to hear before we make our decision? Thank you.
Thank you, Your Worship. Am I allowed to comment on what Mr. Kennedy said?
Oh, absolutely. To the extent that it relates to the matters in the order, yes.
First of all, I just want to point out that I am a nature lover and I love trees. So I am not into taking trees down for no good reason. And I think that's got to be known. Second of all, I am an absentee owner. I'm not present in this community. So I have no knowledge of the trees that were cut down in advance of trees being cut down. I only have awareness after the fact. Okay, so I want to say that. So I object to the wording that Mr. Robert Kennedy used, which was damage to the property. There was no damage to the property. Everything that was done as in a good way. It was normal property maintenance, okay? It was not anything that was intended to bring property damage. And it's really important that we stick to the bylaws, your bylaws, to understand that what we did was not outside of the bylaws. So I don't even know where to start, except I see this as two parts. One is the site alteration and the other is tree cutting. So I want to start with the site alteration because this one I feel very, very strongly about. There was a pathway that existed at the front of that property. It was a pathway, laneway, walkway, whatever you want to call it. It existed in order to access the pump house that was at the end of the cabins that it services. And it's always been there, always been there. I don't think that Mr. Kennedy can point to one tree that came down in that area. We have had an arborist walk the laneway to look for evidence of that, and he is in the process of writing a report. But he could find no evidence of any trees that came down. There was one tree, Mr. Kennedy, that had limbing. And when I asked the arborist about that, there was 2 branches cut, and he said it was way less than 5% of the canopy, and it's not an issue. So that's important for you to understand. So when we talk about site alteration, I think we should stick to your bylaw. And your bylaw says that the owner shall install and maintain erosion and sediment control measures along the edge of the natural drainage course, and cannot demolish, remove material, site alteration, or plant in accordance with Section 1 and Section 4 of 2022-108. In order that this point be valid, that there was a site alteration, you have to prove that there was demolition. There was none. You have to prove there was removal of material. There was none. You have to prove there was planting. There was none. And there's one other thing. This definition of site alteration is in your bylaw. A site alteration means a change in elevation from existing grade or finished grade resulting from the placement or dumping of fill. There was none. The removal of soil or fill. None was removed. The placing, dumping, removal, or rock blasting. There was none. Any other action that alters the grade of land, including the altering in any way of a natural drainage course on a site. There was none. So then I'll take you to your bylaw exemptions. And in your bylaw, section 3 is your set out of exemptions. If you go to 3.2H, it says the placing or dumping of fill, removal of soil, or alteration of grade for the purpose of installing a dry laid walkway or stairway that does not exceed a width of 6 feet in any location. This pathway, walkway, has different widths, but I do have a picture that
Just past your 5-minute mark, so I'm going to have to ask you to wrap it up, please.
Oh, wow. Okay, I don't get much time. No, in no place is the walkway more than 6 feet, nowhere. So in my opinion, this does not, it's exempt. And I think that needs to be recognized here. With respect to the cutting of trees, and obviously I don't have a lot of time to address that, I put it in my notes. We did not cut any trees that were outside of regular maintenance or destruction to property on the thing, which your bylaw allows, and I could read you those sections if I had time. That's all I guess I have time to say.
Thank you very much. Anyone with any questions for Ms. Fawcett? Yes, go ahead.
Thank you. Through you to the applicant, I'm just curious. So you did not lay the gravel?
Yes, I did. We did.
So sorry. So if I can further, so you did do that, but I heard that you didn't do that.
Yeah.
So I'm trying to
No,
understand.
I didn't do it. Okay.
No,
so
but you hired a contractor to do that?
what happened was the pathway that runs through there, there's a water main that comes down from the road that the town put in, and it has, at times, it's like a waterfall, and it runs across the pathway and it causes erosion. And there were paving stones there before, but they had sunk. So when number 10 was doing their driveway, there was leftover stone. So we just said, put it on our pathway. It was an opportunity for us to stop the erosion of the pathway. And that is the dry laid pathway that I talked about that's allowed under your bylaw.
Thank you. And I think that there, either I have a misinterpretation of our bylaws and what I've been as a contractor operating under for the last 30 years. So I had concerns about that description. Thank you.
Thank you. Councillor Zabitz, you were next.
Yeah, thank you. And through you, I guess to staff. So here we find ourselves once again, you know, in terms of interpretation of our bylaws, you know, I would hope as a councillor in a different ward than this is, though, for the whole of the township, that the interpretation of our bylaw, that the bylaws that we're speaking to here on this order, that Mr. Kennedy and his department aren't just making these things up. These charges, if I may call them that, are very much based in fact and photo opportunity here, et cetera. I guess I would ask our department, how, when we level these charges, to what I mean, do we go to our own legal and wash them through and make sure that everything is according to our bylaws, et cetera, et cetera? Or is it, I don't believe it's one person making a decision that this stone was put here and this tree was cut, et cetera. Can you share any comments on that, Mr. Kennedy?
Mr. Kennedy, go ahead.
Through your worship, we do investigations on a case-by-case basis. So when the officer goes to a property, we determine whether or not there is a contravention at the property. So in this situation, like we've attended to 14 Armstrong Point Road. We've seen multiple trees removed on the property. We've seen the crushed gravel deposited at the shoreline with fresh dirt on either side of it, with undermined tree root systems on one side of the pathway. And we've also seen trees limbed for the purposes of constructing that pathway. So based on our current bylaws that we have in place since 2022, if we look at page 2 of my report, under the tree conservation bylaw, we determined that we had 3 different contraventions of the tree conservation bylaw: injure or destroy a tree, injure or destroy a tree without a permit within a community designation. And that is just simply the difference between the first 50 feet versus the 50 to 200 feet of a property in the community designation. And then the third is permit injury or destruction of a tree for the installation of a walkway or pathway. So under a tree conservation bylaw, it specifically says that if you are constructing a pathway leading to water or leading down to the water or in the front yard setback, you are not allowed to destroy any trees whatsoever. You're supposed to meander through the trees. And that is consistent with what planning does when we do site plan agreements. When people want to put pathways, it is specific that they have to meander through the trees and not destroy any of them, regardless if it's taking them down completely or limbing them, you know, whether it's 1 branch or 20 branches. Once you limb a branch, you've injured a tree and you would be in contravention of our bylaw. So based on that information that I gathered at the property, I determined that there was contraventions. We issued this order to remedy and also did lay charges in this situation that were heard this morning and adjourned to October 4th.
Director Pink, you have something you wish to say?
Thank you, Your Worship. Good afternoon, Council. I just wanted to clarify in response to the question, and I completely appreciate the interrelated nature of the matter. However, keep in mind, the charges are a separate matter. That's before the courts. That's not before you. As you do know, Council cannot direct in that regard, that matters before the courts. We do have a public prosecutor that'll review the charges, and they do advise staff once late if they feel there's merit to them, and sometimes they're withdrawn, sometimes they're not. What's before you is an appeal to an order to remedy. So it's another tool that the bylaw division has. They've issued in this case to remedy the site to their satisfaction. Under the site alteration and tree preservation bylaw, property owners have a right to appeal said order. So that's what's before you. So keep in mind, it's not affirming the charges or what's going to happen in court. We're not seeking direction in that regard. The appellant has appealed the issue of an order to remedy to install a sediment fence and to submit a planting plan so that the property is rehabilitated to our satisfaction. And that's essentially what's being asked, whether that should be confirmed or withdrawn.
Thank you for that. Councillor Kent.
I have a question for Miss.
Yes,
Thank
Fawcett.
you.
Yeah.
How, you said that there was a path
Mhm.
there before. How wide was that path? And
It's
was it a
exact-
deer path? Was it a deer
No,
path?
exactly the same it is right now. Not one tree was removed. I would challenge Mr. Kennedy to show us one picture that demonstrates a tree was removed. And the width is exactly the same.
Thank you.
So in terms of remediating that, I don't know how you could ask me to put back something that wasn't there.
Put back some. Councillor Nishikawa.
For you to David, Mr. Pink. It's clarification of what he just said and what we're being asked today and what the applicant is willing to do. And that's where I'm confused of me making any decisions because I haven't heard exactly what the applicant's willing to do. Isn't that what we're supposed to be hearing? I'm not sure.
My understanding, Kennedy can correct me if I'm wrong, is that we asked for a plan of remediation that has yet to come. And I guess that would be the starting point for understanding what the applicant is prepared to do. And it's now, if I'm not mistaken, a month overdue.
I was told those timelines were extended by the appeal, and I didn't have to adhere to that until the end. My hope was that you would understand that there was no site alteration and that it's an unreasonable request. I am always willing to work with council, always willing to work with the town to make this right, but I didn't do anything wrong. So I will I will do whatever you want to appease you, but I didn't do anything wrong. Nobody has done anything wrong on that property except try to improve it.
Anyone with another question, Councillor Nishikawa?
Just want to clarify what we're going to be asked to do at this time. So we don't have a plan of remediation. It will be moving forward, whatever it does at the courts. And unfortunately for the applicant, I think there's a misunderstanding of what is acceptable in our township. And I'm going to just speak about the aggregate that was laid. There's issues with that. And unfortunately, I don't think that the applicant understands rules that we've put in place and the way we've operated in this township for many, many years. And I look forward to, so unfortunately, you to be better educated and to see some kind of remediation plan come forward. But again, I'm not clear what we're being asked at this point.
Excuse me, through me, what's being asked, and I have the resolution right here, is to basically uphold the order that was laid or made a month ago. And it's simple, that's simple. The order itself, I think, was an appendix to the report itself. So we've had a look at it, and not to belabor the point, it's an order to remediate. It's not a discussion of right or wrong. It's not a discussion of, who did what or why did that. The question of the matter, the issue is, from my perspective, there's a breach has been identified of two pieces of legislation or statutes or whatever you call them, bylaws that we know are extraordinarily important to everyone in this township. we spent a tremendous amount of energy building them in the last term of council. And it's not a matter of finding any kind of fault. It's a matter of let's fix the problem that's been discovered. Councillor Bosenworth.
It would help for me to understand what is before the court without causing us any risk. Because logic would say if the court found that there was no violation, then would we still be able to ask for remediation if the court said there wasn't a violation? That's the question.
And I'm going to call on Mr. Kennedy to answer. If you're not comfortable answering that one, just let me know.
Through the chair, this is a very common occurrence. Well, I don't want to say it's common, but if we are issuing orders to remedy under our tree conservation or site alteration bylaw, there is not a lot of times charges are laid at the same time. And again, it's based on the evidence that we've gathered as officers when we go to these site visits and done our research. If for some reason we have never actually lost in court in the 3 years that I've been here in regards to any tree conservation or site alteration charge that we've laid. And I don't think we will anytime soon. But I guess to answer Councillor Boslenwer's question, we've never really run into that situation before where charges would be withdrawn, or if we went to a trial and we did not win, everything would be removed. But in common cases like this, we are always still looking for the property owner to comply with our order to remedy while we are going through court, as that whole situation plays into the resolution at the end of the day when it gets into court. So I don't know if that really answers your question. It's a difficult one to answer because we've never been in that position. But that's the normal way that this is dealt with is if we're going through court, we still ask that the property owner remediate the site and provide us what we're asking for in the order to remedy. And then if they do comply and they do work with us and have the site remediated, at the end of the day, when it comes to whether or not there's a suspended sentence or there's a fine, or if it's withdrawn, that's all taken into consideration by our prosecutor on whether or not the accused works with the township or doesn't work with the township.
Thank you. And I think I would not be going on any limb to suggest there's different standards. It's a different test. And this is an opportunity to remedy damages that are that we don't have to know why they were caused. They were caused. We can see the evidence. If we believe the evidence, we can see the evidence, and we can make an order for remedy, restitution, whatever you call it. Completely separate and apart from whatever the court decides in terms of charges laid for behavioral stuff.
May I say two more things?
Excuse me 1 second. Director Pink had signified, and then I'll come back to you.
Thank you. Through you, I didn't want to belabor the point, but if it assists council, and I appreciate it, I think it's a fair question. And as I said, I appreciate the interrelation between the matters. But our public prosecutor has reviewed the file and has not recommended to staff to withdraw the charges. There's been a first appearance already as of today. I think that's an indication to you that, again, the public prosecutor is familiar with our bylaws and has not advised us to withdraw the charges. The ultimate outcome of the courts we can't speak to, obviously, but the matter is proceeding and we feel there's a violation.
Thank you. Ms. Fawcett, you had a comment?
I do. So first, he mentioned Hydro and we hadn't responded to him yet. Hydro finally contacted me yesterday, so I didn't have time to get it into this council meeting. Hydro has confirmed what we suspected, that they cut a lot of trees, and you guys should be well aware of, because you live here, I don't. December 23rd, there was a huge storm. It was a windstorm. It brought down a lot of trees in the area, and Hydro has confirmed to me that they were on our property. They had to go in by snowmobile because there was so many trees down. And That wood that he's talking about is from those felled trees that we had to clean up. We had to clean it up. So it's really, really important that is understood. And it's also it's important to me that you understand that in your bylaw, dry laid means the method of construction or installation where individual stones, blocks, pavers, sand or gravel are put in place without the use of concrete or mortar, and dry laid is allowed. So the 2-inch stone shouldn't have been a problem. And the fact that it was preventing erosion going into the lake is a good thing. And there is an arborist report coming.
Thank you for that. Does anyone have any other comments? We do have a resolution that I'm prepared to read it. Did I already read it? No. Okay, moved by Councilor Nishikawa, seconded by Councilor Burry. Be it resolved that order to remedy tree conservation and site alteration OTR 2023-13 be confirmed by council. So if we're at that point, if anyone has a comment they want to make, if not, I see no comments. I see no more questions.
I have a comment. How could that
I'm sorry.
resolution be pre-done? How could that resolution be
Thank you very much.
pre-written
Would you
before my comments?
Let me take the seat.
I have that question. Am I not allowed to ask that question?
Not right now. Thank you.
Wow. Okay, so really my attendance here was in vain.
It was not in vain.
You're about to put an order on me that you don't even have enough evidence for. I would like to know your evidence for any tree that was cut down on that pathway. There is no evidence.
Thank you very much.
And there's no evidence for any limbing on that pathway. And a site alteration was
I don't see any more comment. I don't see any question. I'm going to call the question. All of those in favor? And anyone opposed? That carries. Thank you very much. Thank you for that. I am going to, at this point in time, it looks like it's 2:04 by that clock. Take a break until 2:15 if everyone can do that. Thank you very much. We are live. Thank you. We're back. Thank you very much. I'm going to move on to the next report from Caitlin regarding area municipal greenhouse control and climate change meeting. Welcome.
Thank you, Your Worship, and good afternoon, everyone. So the report in front of you is to award a contract for the completion of a Muskoka Joint Area Municipal Greenhouse Gas Inventory and Climate Change Mitigation Plan. Just to remind Council, in 2021, the township committed to the development of a climate action plan in collaboration with the other lower tier municipalities with assistance from the District Municipality of Muskoka. The first step in this development of the climate action plan was the preparation of the climate adaptation plan, which was approved by Council in March of 2022. What is in front of Council today is the results from the request for proposal for the second phase of the climate action plan, which will be the greenhouse gas inventory and climate change mitigation plan. 3 proposals were submitted and analyzed by a joint evaluation committee and given a ranking based on the evaluation criteria set out in the RFP. Based on the results of the review, staff is recommending that the assignment of the completion of a Muskoka Joint Area Municipal Greenhouse Gas Inventory and Climate Change Mitigation Plan be awarded to the firm of TML Engineering Limited for the amount of $153,915 plus HST, subject to each lower tier area municipality receiving similar approval. I'd be happy to assist Council with any questions. Thank you.
Thank you, Ms. Walker. Anyone with questions? Councilor Nishikawa.
Thank you through you to, I'm not going to put you, yes, I am going to put you on the spot, but I don't expect you to answer this. But I am looking for what the district is contributing to this and financially, and a couple of us couldn't find it. So I don't know that you would either.
No, through you. So the district's not contributing financially to this. This is specifically the 6 lower tier municipalities are going into this. The district is just acting in an advisory position if we need guidance on the project.
Thank you. Any other questions? Read a resolution. Moved by Councillor Edwards, seconded by Councillor Bosenworth. Be it resolved that the assignment for the completion of a Muskoka Joint Area Municipal Greenhouse Gas Inventory and Climate Change Mitigation Plan be awarded to the firm of TML Engineering Limited in the amount of $153,915 plus HST, subject to each lower tier area municipality receiving similar approval. And that Council authorize the use of funds from the Climate Action Reserve to fund the township portion of the project in the amount of $25,652.50. And that an agreement satisfactory to the Director of Development Services and Environmental Sustainability and the township solicitor be entered into with the consultant. Anybody with a comment or a question? Councilor Nishikawa.
I think my only concern to you, my only concern is that I hope that the township of Muskoka Lakes gets fair treatment.
That's fair. Thank you. Any other comment? Question? I'll call the question. All in favor? And anyone opposed? No, that carries. Thank you very much. There we go. All right. Oh, we'll do the supplemental. Sorry, we're going to do the supplemental at this point. I don't think I have it. Okay. I'm going to call on Mr. Donaldson since he's at the mic to do what's this doing? Okay. Presentation from the Director of Finance, the insurance renewal issue, please, if you will.
Thank you, Your Worship. So before you is a report, in 2022, we went to market and we got a new insurance provider. This is now year 2 of that arrangement. We actually did a 15-month term with our first go around to get our renewal date moved to October 1st. And that would give us more clarity in terms of what our budget requirements would be. Previously on a July renewal, we were kind of guessing when we were doing our budget as to what the insurance increases would be. And now we know the insurer has brought forward a proposal for renewal, which is a 16% increase. They are indicating that is what they are seeing with most of their clients in the current market. We have there is a number of factors affecting that. Inflationary costs. We have had an increase in our property values for a replacement that's used to determine our property insurance. Claims deterioration on our general liability side that is driven a lot by provincial legislation and the whole joint several liability issue and the 1% that we've talked about many times, where if a municipality can be considered even 1% as part of a claim, then they're usually named on the claim as well by a claimant. So I think this is what we would expect in terms of an increase for this year. I think with that, and no change in coverage, no change in deductibles as well. I wanted to make that note as well. And otherwise, I'm open for questions on this.
Thank you, Director Donaldson. Councillor Kent.
I was just wondering how our claims experience has been. Have we had a lot, or has it been a easy period? Because I mean, I know it's consistent. It's just horrible, the insurance companies these days, but have we had a decent or clear claims experience?
And through your worship, we try to apply a very strict risk management perspective on how we treat claims that we receive and what we report to our insurer. And we try to triage those as best we can to suss out ones that are frivolous versus ones that are seem to be higher risk. I mean, it's difficult to say if it's good or bad. I think that we manage as best we can. But again, I go back to the whole notion that we're named on most, if not all, claims that happen within the municipality just because we're the municipality.
Any other questions, comments? Got a resolution to read? Thank you, Director Donaldson. Moved by Councillor Mazan, seconded by Councillor McIntyre. Be it resolved that the proposal for municipal insurance coverage submitted by Marsh Canada through MIS Municipal Insurance Services for the period October 1st, 2023 to September 30, 2024, at an annual premium of $604,111 inclusive of applicable taxes be accepted, and that the Director of Financial Services be authorized to execute the authorization to bind coverage for the 2023-2024 municipal insurance renewal proposal and any documentation required to implement the municipal insurances for the general insurance program. Comments, questions, all in favor? Anyone opposed? Seeing none, that carries. Thank you. Next, I'm going to call upon the clerk, please, to speak to the second or the last issue on the agenda.
Thank you, Mayor Kelly. The report is before you as per the township's flag protocol policy. Community flag raising requests are submitted to the clerk's department and then brought forward to council for approval. This application is for a flag raising to recognize candlelighters and Childhood Cancer Awareness Month in September. The flag would be flown for a week near the end of this month, where the family and the organization who made this request would hope to be in attendance as well. I'm here for any questions.
Does anybody have any questions? All right, I'm going to read the resolution. Moved by Councillor Zavitz, seconded by Councillor Nishikawa. Be it resolved that the community flag raising request, Candlelighters Simcoe Childhood Cancer Awareness Month, as outlined in the staff report LS-2023-30, be approved. All in favor? Thank you, and that carries. Thank you. We're back to the regular agenda, number 11A, report from the planning technician on the tariff of fee bylaw, the tariff of fees, the bylaw relating to the fees. Oh, there we go. Thank you.
Thank you, Your Worship. Good afternoon, everyone. The report before you is being brought to council to request the reinstatement of fees related to single unit residential site plan applications as a result of recent policy and legislative changes extending from the province's Housing Supply Action Plan. Ontario Regulation 254-23 prescribed areas, Section 41 of the Act, was released on August 9th, 2023, prescribing areas located within 120 meters of a wetland, lake or river, or 300 meters of a railway line as site plan control areas. Staff recommends that bylaw 2023-101, which reinstates site plan agreement fees as according to the original fees for site plan agreements in Schedule F as approved in bylaw 2022-152 on January 17th, 2023, be given 3 readings to further update tariff fee bylaw 2022-152. And that's it. I'm happy to assist with any questions.
Thanks, Rachel. Anybody with any questions? No comments. I got a resolution to read then. Oh, don't move. Moved by Councillor Mazan, seconded by Councillor Roberts. Be it resolved that bylaw 2023-101 to reinstate fees related to single unit residential site plan applications be read a first, second, and third time and finally passed. Any questions? All in favor? Thank you. That carries. Who's up next here? We've got original allowance closure. You're speaking to that, Michelle? Thank you.
Thank you, Your Worship, and through you. Bylaw 2023-099 is for the purposes of stopping up, closing, and conveying portions of an original road allowance to abutting landowners. General Finance Committee provided initial approval of these applications in June 2022.
Thank you. Good report. Any with any comment or excuse me, questions? And then if not, I'm going to read. I'll read. Moved by Councillor Kent, seconded by Councillor McIntyre. Be it resolved that that part of the original that part of the original road allowance between the geographic townships of Watt and Monk, now in the township of Muskoka Lakes in the district municipality of Muskoka, designated as parts 2 and 3 on Plan 35R-26898, be declared as surplus land, and that the clerk is hereby instructed to, bless you, to dispose of the said property pursuant to section 8, 9, and 11 of the Municipal Act 2001, and that bylaw 2023-099 to stop up, close, and convey that portion of road allowance designated as parts 2 and 3 on Plan 35R-26898 be given 3 readings and passed. Questions, comments, all in favor? That carries. Thank you. Okay, cranberry products. Somebody speaking to cranberry products? Or I missed something? Oh, I'm sorry. It's on there. I don't see anybody. Oh, there they are. Oh, hi, Sam. Welcome. Welcome,
Hello.
Mr. Soya.
Hi, good afternoon, Your Worship. So for cranberry products, Council will recall that there was an application to create 3 rural lots, and there is a minor amendment to the zoning bylaw to prohibit a road through environmental protection area or a driveway, and that is the only minor amendment. Thank you.
Thank you. All right, I'm going to read the resolution. Moved by Councillor Zabitz, seconded by Councillor Edwards, who is there. Be it resolved that bylaw 2023-095 to amend comprehensive zoning bylaw 2014-14, Cranberry Products of Canada, roll number 6-17-002, be read a first and second time. Any questions? All in favor? That carries. Thank you very much. We have a minor amendment, and that is moved by Councillor Bosenworth, seconded by Councillor Nishikawa. Be it resolved, the Township Council amend bylaw 2023-095, Cranberry Products of Canada, roll number 6-17-002. And these amendments are minor in nature and do not require further public circulation and are hereby approved prior to third reading. These amendments shall consist of to prohibit the construction of a driveway or road on lands zoned environmental protection EP1. Any comments? All in favor? That carries. Thank you very much. And now we come to third reading. Moved by Councillor Nishikawa, seconded by Councillor Burry. Be it resolved that bylaw 2023-095, Cranberry Products of Canada, roll number 6-17-002, be read a third time and finally passed. All in favor? And that carries. Thank you. Month's file is up, and this is, I think, the last matter before we go into closed. Okay, there is nobody to speak to this matter. We all saw the proposed bylaw and the submissions with the agenda. So in the absence of anything else, I'm going to read the resolution. Moved by Councillor Kent, seconded by Councillor Zavitz. Be it resolved that bylaw 2023-094 to amend comprehensive zoning bylaw 2014-14 months, roll number 2-9-098, be read a first and second time. Any questions? All in favor? Thank you. That carries. Thank you. David, can you okay. I'm sorry. I would think we could. Sure, go ahead.
Well, again, sorry, through you. I was expecting that we would be able to, because certainly as we look at the staff report that says we can't even put a septic in that small area. I would have expected that we would have. I certainly wouldn't be supporting it. Thank you.
So
I'm gonna ask as the clerk, if you could please ask. No, you're gonna ask for roles.
okay, I'm going to, I've never done this one before, ask for a motion to reconsider this, this particular motion. And what I would going to ask the clerk for direction, read this one more time, or just simply a motion. We're going to clean it up with resolutions after we're doing, proposing a resolution that someone will make and someone will second, Councillor Bosenworth, which would be a motion to reconsider. How do we identify this? Okay, bylaw 2023-094, the first and second reading, the resolution that was just read. So we have a motion to reconsider that, which is the simple one. Sorry, you have a question?
Yes. Table. So I just wanted to remind people what we're talking about, and that this was a district situation as well. And again, we had history from this previous applicant, or there wasn't an application in the past. And so district went in and removed the situation in the past, and now they're looking for approval of it. And we didn't move it forward, and hopefully we won't. We're moving it forward. It's too small. The lot's too small.
Any other comments before we do this? I've read the motion. Oh, sorry, outside there, Councillor Edwards.
Yes, I would just like clarification because at the planning meeting, we defeated this. That's why I did not support the motion that was just read. And
Okay.
and if we're making motions in planning to defeat something, it should be coming to council to defeat it, and that so we don't make a mistake like this again.
That's a fair comment. Okay. All right. So we have a motion on the floor, moved and seconded to reconsider that last one. I haven't called for a vote on this yet, have I? All right. All in favor? And yes, we're going to reconsider. Thank you very much. So this one that I had read a minute ago is back on the table. I will read it one more time and then we'll probably have a quick discussion before we call a vote. Moved by Councillor Kent, seconded by Councillor Zappas. Be it resolved that bylaw 2023-094 to amend comprehensive zoning bylaw 2014-14 months, roll number 2-9-098 be read a first and second time. Anybody with any questions? Anybody with any comments? Councillor Edwards.
Since it is read in the positive, I will not be supporting it, so it will be defeated. Thank you.
Thank you very much. All right, so I'm going to have read it. No more questions or comments. I'm going to call a vote on this one. All in favor? Anyone opposed? Thank you very much. Just take 1 minute for direction. Okay, with that, we are done. There will be nothing further to do on that particular matter since it was defeated. We got a future meeting schedule and we are about to move into closed session. We could do that, please. Need a resolution moved by Councillor Burry, seconded by Councillor Zappas. Be it resolved that council in closed session convene at 2:38 p.m. for a litigation or potential litigation, including matters before administrative